Well, good afternoon. My name is Jack Lloyd. I'm a supervising attorney with the Economic Justice Initiative of Legal Aid. And part of what we do at the Economic Justice Initiative is handle issues related to foreclosures. And what I wanted to talk about today was something that comes under what's called the CARES Act, which you probably have seen and are familiar with from the news. The CARES Act, Coronavirus Aid Relief and Economic Security Act. And there's a particular provision, there are two particular provisions that I want to talk about today. One I'll just deal with briefly, and then the other one I will deal with a little bit more specificity. And let me just say that although this was recorded earlier and is being shown later, if you do have questions, you can type those in to the chat box area, and those questions will get to either me or another attorney to answer. So let me just start by, again, clarifying what this thing is called the CARES Act. Now, the CARES Act, the Coronavirus Aid Relief and Economic Securities Act, provides two specific defenses to homeowners during this pandemic. And when I say defenses, what I mean, two opportunities that people have, that homeowners have, to avoid foreclosure if they're dealing with some type of COVID-related economic hardship. Okay, so if under the CARES Act, if you as a homeowner are dealing with an economic hardship as a result of the coronavirus pandemic, you have two avenues of protection to avoid a foreclosure during this period. And the first one is just a straight out moratorium. It's called a moratorium. And what that means is that for certain mortgages, until the end of this year, so until January 1 of 2021, no mortgage servicer, that's the party who sends you your mortgage updates, your mortgage invoices that you contact with questions about your mortgage servicer, no mortgage servicer of a federally backed mortgage. I know you're thinking, do I have a federally backed mortgage? I'll get to that in a second. No servicer of a federally backed mortgage can proceed with any aspect of a foreclosure until the new year. They can't notice a foreclosure hearing. They can't proceed with a foreclosure hearing. They can't try and get a foreclosure order. They certainly can't proceed to try to act on a foreclosure order, even if it was already obtained prior to the pandemic. Everything, if you have a federally backed mortgage, is on pause until the new year. Okay, and before I get to the other aspect of the CARES Act and how it can help a homeowner who's financially impacted by the coronavirus, let me briefly answer the question, what does that mean, federally backed mortgage? Well, what that means specifically is if you have a loan that is backed by the federal government, and by backed, I mean a loan that is securitized, insured, guaranteed by Freddie Mac, Fannie Mae, the Federal Housing Administration, an FHA loan, a Veterans Affairs mortgage, a United States Department of Agricultural and Home and Rural Home Services, or RHS backed mortgage. If you have those mortgages, you make up over 2/3 of the mortgages in the United States of America, they cannot proceed to initiate any aspect of a foreclosure during this year. Okay, so you're saying to yourself, okay, Jack, so it sounds like a lot of these mortgages out there are actually federally backed mortgages, Fannie or Freddie or VA. Well, how do I know? Well, some of them say right on the invoice, the little invoice that you get emailed to you or mailed to you each month by your mortgage servicer may indicate right on there, this is an FHA loan, this is a VA loan. It may be in your mortgage documents, your deed or your mortgage promissory note. I know you're thinking, there's got to be a better way than me digging through the attic to find all this paperwork. And there is. And it's at a website and there's a website that is called the Consumer Finance Protection Bureau, the Consumer Finance Protection Bureau, and they have a website called consumerfinance.gov, consumerfinance.gov. And you can go onto that website and they have a special COVID section. And under that COVID section, they have a drop-down menu and that specifically is entitled, How Can I Tell Who Owns My Mortgage? How can I tell who owns my mortgage? And they'll ask you some questions about it, and you'll get that information off your latest mortgage statement and be able to plug that in there. And then they will be able to tell you or route you to a place where you'll be able to find out whether or not you have a mortgage that is insured or guaranteed or securitized by Fannie, Freddie, VA, FHA, Rural Home, etc. Now, so you go to the website. What was it again? Consumerfinance.gov. And that's the Consumer Finance Protection Bureau. So consumerfinance.gov, just Google it. It'll come up. Go to the COVID section. You can't miss it. Obviously, it is the question most people have right now when they go to the Consumer Protection Bureau. And under the COVID section, you'll have an option. How can I tell who owns my mortgage? Put your information into that. If you have a federally backed mortgage, you will find out, and you will know that if anyone attempts to initiate a foreclosure against you until the end of this year, they are violating the CARES Act, and you need to contact legal aid or another attorney to help you sort that out because they're in violation of the CARES Act. Okay. There's another aspect to the CARES Act other than the moratorium, which provides homeowners potential relief if you are experiencing a COVID-related financial hardship. And let me just stop there and just, right now in the United States of America, if you are alive in the United States of America, you're somehow financially impacted probably by COVID, right? So that's good news. You don't have to call your mortgage servicer and talk to them about how you were financially impacted. They're not allowed to ask you to prove you were financially impacted. Why? Because when Congress enacted the CARES Act, everybody knew with the economy falling apart, everyone at some level was going to be impacted by the COVID pandemic. And so all you have to do is tell your mortgage servicer, I am impacted by the pandemic financially, and your attestation is your confirmation, that all the confirmation that they are allowed to ask, not to give, that they're even allowed to ask about. At that point, you get the protection. Okay, you get, first of all, there's the moratorium. They can't even be proceeding against you. But secondly, if you are impacted financially by the COVID crisis, by the pandemic, you're allowed to get what's called a forbearance. You're allowed to ask your servicer about forbearance options. It's a forbearance. A forbearance is an opportunity to either lessen or pay nothing for a certain period of time on your mortgages to allow you to get financially back up to speed with your finances, with your life. And all you have to do, if you have a federally backed loan, and where do you find that information again? Finance.gov, COVID, how can I tell who backs my mortgage, who owns my mortgage, and you'll find out. And if you have one of these federally backed mortgages, you may call your mortgage servicer. First of all, we know there's a moratorium, so they shouldn't be doing anything foreclosure-wise with you, but you may call your mortgage servicer and you may say, I have a COVID-related financial hardship in my life, and I would like to forbear payment on my mortgage for a certain period of time. How much time are you allowed to ask for? 180 days, at the end of which you may ask for another 180 days for a grand total of a year. That's right. You have an opportunity, if you have a federally backed mortgage, to call your mortgage servicer and request a forbearance of your mortgage payments. You don't ask for the whole year up front. You ask for 180 days, at the end of which you're allowed to ask for 180 days. Now, there's some downsides to this that I want to talk about. I know a lot of people are thinking, oh, this just don't pay a mortgage. Okay, it's true. However, during that period of time, this is not a grant. This is not, well, you just pick up again later on when you want to start paying your mortgage and things were where they were. All the money that is owed during that period of time, including interest, continues to be owed. Okay, so you have an opportunity to stop making your mortgage payments. However, you need to sit down and really think through whether or not and how long a forbearance you really want. Now, there's a little bit of a tricky part here. The tricky part is each one of those federally backed loans, the VA, the FHA, the Fannie, the Freddie, the rural housing, all have variations of how you're going to pay back the money, how quickly it has to be paid back. So let's say, for example, you have a $1,000 a month mortgage, just for simplicity's sake, a round number. And you decide, I don't want to pay, I can't pay. I'm having significant financial, again, you don't have to prove that to your mortgage servicer, but you decide whether or not you are in a place where you would like a break, and you need a break financially from making your mortgage payment. And you call your mortgage servicer and you think, okay, I'd like, 6 months of not paying my mortgage will really allow me to jumpstart my economic life and to handle the problems I've been confronting as a result of the pandemic. Okay, I want you to think about that. Over those 6 months, how much do you pay? We said hypothetically $1,000. So over a 6-month period of time, that's $6,000 plus interest that accrued. Now what happens when you pay that back? Again, you have to find out who owns which federally backed kind of mortgage you have, Fannie, VA, VHA, FHA. And then it will tell you what the payback models look like. Some you can put at the very end of your mortgage payment. Some require payment a little bit sooner. This will determine whether or not you think that getting this forbearance is a wise for you. Because let's say you take the 6 months. Now you got $6,000, okay, plus interest. Now, how are you going to pay that back? What if you have to start paying a little bit more each month starting, 4 months? That means $1,000 to $1,100 a month. Now you're going to have to factor that in. What does my economic situation look like? Well, will I be able to afford a $1,200 or $1,300 mortgage payment? Now, again, some of them allow you to put it off. And my point is not to avoid getting the forbearance. The forbearance is in talking with colleagues around the state and across the country who do the work that we do with mortgages and foreclosures. It is the consensus of the attorneys that I have interacted with that this forbearance may be the lifeline that provides more help to more homeowners over the course of the next year than anything else. And so it is a wonderful tool. All we tell people is that just remember, it's not free money during that period of time. There's going to be a payback program, and those do vary, and you need to find out which payback program model you have or you're going to have, and then figure out for yourself what is the best program for me as far as how long should I ask for forbearance. And my time about up, and we just wanted to give an overview and just let you know that right now under the CARES Act, if you federally backed loan and anyone attempts to move with a foreclosure at any level, they're violating the CARES Act. Please see an attorney. Secondly, if you are having a COVID-related financial hardship in your life in any way, you are entitled to a forbearance on your mortgage payments for up to 180 days plus another 180 days. Those are the big takeaways you need to know at this point. Just to be aware that these opportunities are there for you. and to help you survive during this pandemic. And one word of caution, then I have to go because there's another speaker coming on, but something that's important. We have been told, and I have confirmed this with, again, attorneys who do what I do across North Carolina and across this country, that some of these mortgage servicers are, how should we say, not bending the truth a little bit when they talk to their customers about forbearance options. What I mean by that is they're trying to convince homeowners, you really just want to do 30 days, not 180, and certainly not the 180 plus 180. You only want to do 40 days. We're only going to allow you to do 30 days. These kind of comments, if anyone gives you any pushback when you call your mortgage servicer to request the forbearance that you have a right, they do not have a right to make a decision about how long that is. That is your right. You can't get more than the 180 plus 180, but you can get 180 plus 180, and they do not have a right to narrow that down. We are being told that some of the more fly-by-night operations are suggesting to people when they call for this forbearance, not really entitled to that they have to take what the mortgage servicer wants to give them. That is not. And if you run into that, just like if you run into any other foreclosure business right now in a federally backed loan, you seek an attorney, call legal aid, call an attorney that you're comfortable with, but you should seek legal help because, again, they're in violation of the CARES Act. Those mortgage servicers would be in violation of this federal law, and you should get an attorney to defend your rights. This topic is more complicated than I've had the opportunity to share with you right now. And if you have further questions about it, start with consumerfinance.gov. They have a wonderful, easy to follow website, very user-friendly to provide information for homeowners. And if that does not satisfy your needs, then as always, we recommend that you seek legal counsel. Well, thank you very much and good luck. And I will now turn it over to my.
I have a question though before you go, Jack.
So, oh, yes, ma'am.
Listening to you, Jack, Mr. Lloyd. I'm Kelly Clarke. I'm with the Fair Housing Project. I know we didn't talk about this, but you're going to know the answer, so don't worry, Jack, about what I'm about to ask you. But I'm Kelly Clarke with the Fair Housing Project. I work with Mr. Lloyd, Jack Lloyd, for several years, and so what I got from your presentation, besides many other things, one is that is it a max of 1 year that's allowed for the forbearance per this statute that you're talking about?
That's right. So and you just reminded me of something else. So thank you very much, Kelly, for that.
I got another question for you after that, so keep going. But I want to ask.
You can ask for 100 days. You can't ask for the full year up front. You start by asking for 180, but it is your right. It is the homeowner's right to then request an additional 180 days. But let me just say this. We were talking about the end of the year as the timeline for the moratorium. If you're a homeowner and you think you may need a forbearance to help you as a lifeline during the coming into the spring and the summer of next year, do not wait until the moratorium is over. Because at this stage, we think that there's a possibility that at the new year, the moratorium will end and an opportunity for the forbearance may end as well. Because the COVID emergency that initiated the CARES Act may be over at that time. That is uncertain, but with an abundance of caution, we recommend to all homeowners, I know because people are thinking to themselves, well, there's a moratorium now, so I don't have to think about this until we get to the end of it. Okay, that's logical thinking, except, let me again caution you, at the end of time, it may be also the close of when you can ask for. Do not wait until the new year to ask for the forbearance. Sit down, figure out your finances. If you have a partner, work on that, decide what may be right for you, and seek that forbearance this autumn before we get to the end of the moratorium. So thank you, Kelly. I almost forgot.
No, but this is my next question. So I heard you say that only under the CARES Act you get the 1 year. That's the max, correct?
That's correct.
All right, so one of the law that my office primarily deals with, what we deal with is the Fair Housing Act, both the federal as well as our state in North Carolina, the Fair Housing Act. And so there are, potentially, I'm just putting this out there, potentially of going maybe beyond a year under the Fair Housing Act, is that if you have a disability and your disability is playing a role in the behavior here, potentially with the ability to pay your mortgage payment. Now, it's not a guarantee, but that's
Right.
potential. I'm just trying to see what you think with this, Jack.
I-
Is that
well,
the
what
Housing
I-
Act could be potentially a way to ask for more time than the year.
So I think that's a great point. And it's a great question. And at this point, we don't know or I don't know the answer to it. In full, but so there are a couple things there. This whole pandemic has been such a fluid situation. You have the rules of civil procedure in the courts here in North Carolina. The application and the rules for how CARES is being administered have been constantly evolving.
That's
because
right.
as science changes and we learn more, as the economy changes, and everyone's trying to figure it out, and this is not an easy thing, and we're learning together. Things have been changing, and so there's a possibility that both the moratorium and the forbearance may get extensions, and with rules and laws that you're talking about, may be able to dovetail with other things. That's absolutely true, and it would not surprise me at all, since that is the nature of this beast, is an evolutionary process. But for as much as I think that's probably not only possible but likely, you just don't know. And because this has the potential for torpedoing your ability to make your mortgage payments and stay in your home, we highly recommend that people, as we move into the fall, become proactive on this. Yes, I hope that's what happens. I hope these things get extended. But I just think that people need to be very careful here, and do this now rather than later.
Yes. Okay.
Thank you for those questions.
Sure. So my part of the presentation is, and again, I'm Kelly Clarke with Legal Aid of North Carolina for Housing Project. And my part of the presentation was just to give some updates with fair housing. And, our project is still looking into these updates, as Jack Lloyd was talking about with certain things. It's just evolving, understanding. But what I wanted to touch on today were maybe some updates that you've seen about HUD and new rules or final rules that they've put in place. One, if you might have seen in the news, about disparate impact. Another about affirmatively furthering fair housing. If you have caught any of our other presentations at Legal Aid and you've seen my colleague Yolanda Taylor talking about fair housing, she's always talking about affirmatively furthering fair housing. And so HUD came out with a rule this summer also about affirmatively furthering fair housing and changes to the prior rules. Both the disparate impact rule that just came out, as well as the affirmatively furthering fair housing, were replacing previous rules that HUD had and that were promulgated and released under President Obama's administration. And then I also want to talk about a Supreme Court case that came out that has implications in the fair housing arena. It was an employment discrimination case. Employment discrimination, a lot of cases come under Title VII of the Civil Rights Act, and there was a case that came out this summer dealing with the rights under Title VII related to sexual orientation and gender identity. And a lot of Title VII cases are used. Now, there are some differences, and so there's some Title VII cases that are not looked to, but in the Title VIII or the fair housing realm, Title VIII of the Civil Rights Act is the Fair Housing Act, the Federal Fair Housing Act. So I just wanted to briefly talk about those. And so again, my project is still looking into these, into particularly the new disparate impact rule and the new affirmatively further fair housing rule. But I just wanted to give some highlights, or just some basic things that we're getting out of it, and that what you might have already seen in some of the news reports. But I just wanted to go over those briefly. So affirmatively furthering fair housing, that is this affirmative duty. Now, the Fair Housing Act was passed after the assassination of Dr. Martin Luther King, a week after he was killed, after a week after he was murdered. And it prohibits discrimination on race, color, religion, national origin, gender. Also, discrimination is prohibited on disability and familial status. So seven categories. So people can't be discriminated against in rental or in the buying of a home on those bases, on those protected characteristics. Other part, and this statute was passed, this law was passed on the federal level in 1968. It has in there this affirmative duty by HUD and other federal agencies to affirmatively further fair housing. So in addition to people and so forth can't be discriminated against, there's this affirmative duty by federal agencies like HUD and so forth, as well as recipients of federal funds. So that's going to be state and local governments. It's going to be public housing authorities, counties, and so forth that receive federal funds. You've heard of community development block grants, CDBG funds, those type of funds that they have to show how they're affirmatively furthering fair housing. Not in addition that they're not discriminating, but they're doing these affirmative steps, because we know that segregation in our country, it wasn't unintentional. It didn't just happen by happenstance or by mistake. And so, this affirmative duty under the Fair Housing Act, it's in the statutory language. It is this requirement. And so what does it really all mean about how to affirmatively further fair housing? Well, HUD has put out rules in the past, and most recently, I believe it was in 2015. There were already some HUD guidance before that, but you probably have heard of the term. If you're in the Triangle area and you know of a housing right advocate as well, Octavia Rainey, she talks about analysis of impediments often, right? And that is this duty of cities and counties and states to be looking at what are the impediments to fair housing and how to overcome them. So there's this document that's developed to look at these barriers to fair housing, to integration, and how to overcome them and how cities are supposed to do that. Now, before these rules were put into place, because the duty is in the statute, there have been challenges to cities acts and counties actions saying that they are not affirmatively furthering fair housing. And there have been challenges brought in courts before these rules were put into place because of the statutory language. So just to be mindful of that. One famous case, if you Google it and look at it, it was brought by the Anti-Discrimination Center in New York against Westchester County, New York, and how they were not affirmatively furthering fair housing. It was a federal lawsuit that was brought in 2006, and they received a favorable decision by the federal court in 2009, and it was millions of dollars that had to be returned by the county with HUD and monies that were not received because they were not affirmatively furthering fair housing. And that was before the rule promulgated under the Obama administration in 2015, and obviously before this new rule that HUD has now replaced the 2015 rule. Differences that this new rule that has come out, it came out in July, is now effective. It was not even called affirmatively furthering fair housing. It was called preserving community and neighborhood choice, okay? And under the 2015 rule, there were all these tools that were available and that were required to be used by cities and counties and states about how they were going to overcome these barriers as recipients of these federal funds, barriers to fair housing. And tools, what I mean is as mapping out, looking in the particular region and area by census data, by just historical landscape, what these barriers were, why we were still having segregation, and what could be used to dismantle that. Those tools are and that was accessible through HUD and their HUD's website. That's no longer accessible. In 2018, HUD suspended the deadlines that were put into effect by the 2015 HUD rule, and they also took away these tools that cities and counties could use and states could use, recipients of federal monies could use in coming up with these plans or these assessments of fair housing. And so now with this new rule, what recipients can just say that they can certify, they can sign a document, say that they're certified, that they are in good faith, they are affirmatively furthering fair housing. And so there's a certification that is going to be basically the way that cities and counties and states can say that they are complying with the Federal Fair Housing Act. Now, remember, there was the Westchester County case that was brought, same type of thing, where that was being certified, but the plaintiffs in that case were able to show, using data and tools that they had, how that wasn't happening. So it still is possible. And again, that duty is in the statutory language of the Fair Housing Act. So regardless of that, the rule there, that is there. But that has been a recent change. So that was in July. Another thing that has just happened it was right around, it was Labor Day, is this new, what's called a disparate impact rule by HUD. Now, disparate impact is a way to show discrimination. It's actually a way to show unintentional discrimination. It is, discrimination can be intentional based on the 7 characteristics that, race, color, religion, national origin, sex, also familial status and disability. So on that basis, but also you can have on its face a facially neutrally policy or rule or practice that doesn't call out any of the 7 protected characteristics, but in its application is having a discriminatory impact on one of those groups. For instance, I brought up in a prior home presentation about these ordinances throughout the nation that would fine landlords if there were too many calls to law enforcement by one of their tenants or so forth within a month. Well, national and local statistics show that the majority of survivors of domestic violence are women. Sex is a protected group under the Fair Housing Act. And so there have been successful challenges to those type of ordinances by saying, this policy about fining landlords, it doesn't call out sex on its face or gender on its face, but its disproportionate impact is going to affect survivors of domestic violence because they are going to be calling law enforcement on more of a basis than someone who is not, and the survivors are predominantly women. And actually, the statistics also show, national and local, that it's women of color that are the primary survivors of domestic violence. So actually then potentially 2 of the protected groups under the Fair Housing Act were disproportionately impacted by this facially neutral ordinance. So that's an example of using disparate impact to show potential discrimination that's prohibited under the Fair Housing Act. Well, how this, you just don't show that it's just, the statistics is not all you need to show in order to show a disparate impact type of case. You have to show, yes, national and local statistics reveal this, then that's the burden on the plaintiff. Then the burden goes on the defendant, usually the city or whoever has this ordinance or so forth, or the landlord that may have a policy or so forth, and they have to show that there's actually a legitimate reason of why they have this practice or this policy or this ordinance in place. And if they can show that and back that up with data and information, then the burden would go back to plaintiff to say, well, actually, there's a less discriminatory way you can do this. So it's a 3-burden test. Well, with this new disparate impact rule that's come into place, it has now added more things that the plaintiff or someone who's trying to challenge and to say that this type of discrimination is happening has to show. And it's actually, from some of the commentary and reading the rule, they're saying it's now a 5. It's a 5, the plaintiff has to show 5 different things before, and that's more than what had to be shown originally. And so it's just, and also the new rule comes up with defenses, additional defenses that the defendant can raise to say why they're not discriminating. So there's also that in place with the new rule. So that's different. Again, we're trying to figure out all the ins and outs. Also, a really good tool or a really good place to look at this is also at the National Fair Housing Alliance. They have published some really good information, both on the affirmatively furthering fair housing rule, as well as the new disparate impact rule. But just be also mindful that the United States Supreme Court in 2015 upheld this theory or this way to show discrimination through this disparate impact, that's what it's called, this non-intentional type of discrimination in 2015 in a fair housing case. So you do have that, that as well, in addition to what you see in this rule. It's good to be mindful of that that this type of theory is also used in Title VII employment discrimination cases. That's how it was looked to for Title VIII to be bringing this, but it's also this type of liability, of looking at liability, goes back decades under the Fair Housing Act, since at least 1971 or 72. So the third thing I wanted to talk about was about the recent United States Supreme Court case in Bostock about that recognized under Title VII, so employment discrimination, Title VII of the Civil Rights Act, that firing someone based on their sexual orientation or being a transgender person, that is discrimination under Title VII under sex discrimination. So it's not just of thinking of the traditional male, female, or what we think of as the biological sex. It's also expanding to be sexual orientation and gender identity. And that has implications in the Title VIII context, in the Fair Housing Act, in the Fair Housing Act cases. So that is an exciting development. Now, I'll also bring up with this that in July, HUD also came out with a proposed rule that was changing previous rules that had come out with in 2012, or guidance that came out with in 2012 and 2016, known as its equal access rules, which said that discrimination based on sexual orientation and gender identity were prohibited in HUD-funded properties or HUD-assisted properties. In this this past July when HUD came out, they said, well, and shelters, because the Fair Housing Act also applies in most, and it can apply in shelter situations, that was going to be based on biological sex and not how there were protections for persons who were transgendered. That was no longer going to be the case under the equal access rule that it previously come out with. So HUD was asked, well, does your position change because they came out with this proposed rule and then the United States Supreme Court came out with their decision in Bostock afterwards? And so it was asked by senators and to members of Congress wrote a letter to HUD to ask if they had changed their position on that based on the Bostock decision. And HUD has said no, that their position has not changed on this new proposed rule they're coming out with about affecting shelters. So those are the three updates that I have. There will probably be more information about that, or maybe we could talk about this in have more time and talk about it more in another home presentation. But thank you very much for listening and being available. And again, as what Jack had mentioned before in his presentation, if there are any questions, we will get those questions. All this is being recorded and we will get answers to you. So thank you very much. Bye-bye.